Good morning. I hope everyone had a great holiday weekend. And here we're back to normalcy, okay? So today is Monday, April 1st. Welcome to the First District Court of Appeals. We have 6 cases on the docket this morning, only one, actually we have 5 cases on the docket this morning, only one is scheduled to argue this morning, which is the first case that's on the docket. If the attorneys can please identify themselves and their readiness to proceed. Let me call the case first, okay? So it's case number C230365, Southwest Ohio Regional Transit Authority versus Sweeten.
Your Honor, Mr. Graff and I are here on the case of Thomas Wynn versus Beatrice.
Oh, that's correct. See, I had too much Easter ham.
It's all right.
Actually, I had no Easter ham. That's submitted on the brief. So the second case is the one that's scheduled to argue, which is case number C230341. Thomas, and is it Wine or Wayne?
It's Wynn, Your Honor.
Wynn, Thomas Wynn versus Beatrice Crum. Okay. If attorneys can please identify themselves and their readiness to proceed.
Your Honor, I'm David Prem. I represent the interest of Beatrice Crum, who is the trustee of the trust that's at issue recently.
My name is William R. Graff. I'm representing the appellee in the case, Thomas Wynn.
Thank you so much. Then we have cases number C230198 and 199, which is Hendrick versus Durrani. That has also submitted on the briefs. Cases number C2302000201, Hill versus Durrani, submitted on the briefs. And cases number C230196, 197, Harrison versus Durrani, submitted on the briefs. Okay. Attorney Prem, on behalf of Ms. Crum, if you can come forward. Good morning again.
Good morning. May it please the court.
How much time would you like to reserve?
A couple of minutes.
Okay.
Just 5 minutes would be fine.
Okay. 5 is usually not a couple, it's several, but we'll go with 5.
Thank you.
All right. And
Although
if you go shorter than your 10, I will carry it over, okay?
Thank you.
You can start whenever you're ready.
I would just say that although the briefs that have been submitted with the court and the record are kind of voluminous, the issue in this case is very simple. It's an issue of how a trust, a testamentary trust or an inter vivos trust in this case, is to be interpreted when there's an issue with respect to its meaning. The case law couldn't be any...
This case distribution was triggered by the death of the...
of the creator of the trust. There was some confusion. First of all, because the trial court decided to look at the trust only, the 4 corners of the trust document only, to determine whether or not it was ambiguous. There's very little factual information that was taken in by the court. Frank Wynn, who was the person that created the trust, died and had 14 children who are the beneficiaries of this trust. They're the 14 litigants in the case that's pending before the probate court.
Well, the trial court did not find it was ambiguous, right?
No, the trial court said that the provision of the trust that deals with the real estate clearly and unequivocally required the trustee to transfer the property, the real estate, in kind to each of the beneficiaries. And that's Article 4 of the trust, Section B1, is what the trial court found.
And counsel, didn't the trial court add a statutory burden to this, basically imputing some kind of time responsibility that this obligation to distribute the property in kind occurred immediately upon death? And then your argument is that Article 5, Section P allows some period of time to sell the property and then distribute it in money instead?
Yes, Your Honor. We also argue, more importantly, that Article 4, that the trial court erred in finding that Article 4 unequivocally requires the trustee to convey the property in kind, because one of the laws I cited says when you're looking at a trust, you have to look at it as a whole. You don't pick apart or take a section unless the section itself clearly says this section only applies here and isn't affected by other sections, which is not what this trust says. The two provisions of the trust that I would encourage you to look at as a starting point are in the same article, Article 5, Administration of the Trust following the death of Frank Wynn. B1 deals with real estate. B1, small I, deals with real or personal property. And the judge mentioned it in his decision, and it was really the only piece of personal property that I'm aware of that the trust owns because there's an estate. But the personal property that the trust owns is a tractor. And if you look at the if you look at what the section says about conveying real estate, it says trustees shall divide all real estate then remaining in the trust into 14 shares. Trustees shall distribute one such share outright and free of the trust to each of Frank L. Wynn's children.
And this is Article 4 that you're quoting from, is that correct?
Yes, Your Honor.
Okay, so Article 4 governs the administration of the trust following death.
Yes,
Okay, but there's also language in Article 5.
yes.
Now, the language in Article 5, is it limited as to what triggers the distribution of the assets or the determinations that it gives the trustee authority under Article 5?
No. Article 5, Section P says, upon any division, distribution, allocation, or apportionment of any asset, trustee may make such division, distribution, allocation, or apportionment in money or in kind, or partly in money and partly in kind. If you go back to Article 4, where it deals with the real estate and it deals with the tractor, the personal property, the trustee used the same language for each section. And so the question is, well, if the trustee's required to convey the real estate in kind, what did the trustee intend, or what did the grantor intend with respect to how these people were going to receive their interest? Is he dividing the property? There are 4 tracts of real estate. There are really 3 at issue. But the one tract that the parties agreed to sell is a residential house on like a half acre. Did the creator of the trust really intend that the trustee give a residential piece of real estate to 14 people? And then what interest are they getting? Does he have to divide it into 14 shares, into 14 tracts, which you couldn't do? Does he give it to them as tenants in common? Does he give it to them as tenants by the entirety? Does he give them a fee simple interest on a condition subsequent? Did he intend for the spouses to have it? What would happen if someone died, one of the kids died before he did? Well, the next article, Article 5, deals with all that. It gives the trustee the direction and the power and the authority. If a brother or sister died before the grantor, that person's share goes to his heirs per stirpe. So if he's got 3 kids, they don't get a 1/14th interest, they get a 1/42nd interest. There's 13 people that would get a 1/14th
I mean, it
interest.
seems to me that what you're saying is that Article 4 is governing how to divide the assets,
Yes,
okay, amongst
yes,
the beneficiaries,
yes, because,
while Article 5 governs, and it's entitled Powers, Duties, and Immunities of Trustee. Now, immunity is not really at issue here, it's powers and duties.
yes,
So it governs powers and duties, but Article 5 doesn't seem to limit itself to only powers and duties, whether it's on the death or before the death.
correct.
Because wasn't this a trust that was created and gave the trustee that trustee title and authority prior to the death?
Exactly, yes,
Did I make sense there?
yes, you did,
Okay.
and that's
It
one.
seems like that's what your argument is. Is that what your argument is?
Yes, and that's one of the points that I tried to make in my brief, is that there's the argument, the appellee's argument was, if this is clearly and unequivocally an intent on the part of the trustee to have these properties distributed in kind, to transfer the title to the property to the beneficiaries. And that can't be, and the appellee and the trial court relied on some statutes, which are the statutes that regulate how the trustee has to act, but those statutes don't take away from the express meaning of the trust. They just
Doesn't the
basi-
ORC itself actually say that, and I can't remember the provision, that the ORC is going to govern, but of course, if there's anything specifically provided in the trust, that will govern that.
Exactly.
That portion that is specifically provided in the trust.
Unless for some reason the trustee was ordered to do something in the trust that's unlawful, or the trustee was going to engage in an activity that breached the trustee's fiduciary duty, then those statutes kick in to say, no, you're not allowed to do that. You have to follow the law. But when the clear express terms of the trust provide how the trustee is supposed to handle and distribute the property, then the court shouldn't step in and make a decision to the contrary.
Counsel, it seems to me that there's a step in between the real estate being divided in kind and the real estate being divided in money, and that's selling the real estate, right?
Yes.
The trust also allows the trustee to sell the property, is that
Yes.
right?
At the trustee's discretion, the trustee can sell the property upon such terms as the trustee determines to be appropriate. And that's where those provisions that are cited by the appellee might come into play. If the trustee is going to sell a piece of property that's worth $300,000 for $1, then maybe that trustee has overstepped his or her authority in doing that. But
And to the extent the beneficiaries might worry about the process of this land being sold, is that something that the probate court can manage?
the probate court is vested with equitable power to do what the probate court thinks is fair, but the judge's ruling wasn't based on equity. The judge's ruling was based on this is the law and this is what the trustee has to do, and so that's why it's in error. And one of the things that I said, I have two assignments of error. My first assignment of error said that the court erred in ruling that the trustee must convey this property in kind. The second assignment of error is, the law is clear, when something's ambiguous, the court can conduct a hearing to determine what the grantor's intent was.
But the court didn't say it was ambiguous, and you're saying it's not ambiguous.
I do not believe it's ambiguous, but I'm saying that Mr. Graff is a pretty smart guy, and he disagrees with me. So if he and I disagree, and if I disagree with the judge, he's smarter than me, there must be some ambiguity in there that gives somebody the opportunity to make these arguments that we're making. And all I'm saying is a fallback. I'm not asking the court to grant this relief, but I'm saying as a fallback, at the very least, this matter should be remanded to the court so the court conducts a hearing into the grantor's intent. Because I think it's, if Mr. Graff is correct, then why are all these provisions in this Article 5? Why did the trustee or the grantor waste the time to put all those provisions in? And then if you go back to the tractor, did the grantor intend, because it's the exact same language, did the grantor intend that the trustee saw the tractor into 14 pieces? And the judge even said in his ruling that that's clearly not what he intended, but then the judge used some argument to separate that from what I think the trustee's true powers and clear powers are.
Counsel, I haven't personally inspected this land, but I would assume that it is a physical impossibility to slice 3 separate non-contiguous tracts of land into 14 equal pieces.
That would be something we present if we had to have that hearing, is that's not a part of the record because we didn't get to give the court evidence, but that is a realistic concern. You know, the issue is there are 3 separate tracts of land. One of them is about 12 acres. One of them's like 15 or 16 acres. One of them's 25 acres. I don't know those numbers exactly. One might be contiguous, one's across the street. I don't know if one of the tracts like overlooks a river and it's got a better view, or I don't know how the trustee would determine how to divide them equally. You'd have zoning problems. This isn't in the record, but I did put in my brief, the parties settled the issue of Stanton, which is the property in Hamilton County, to sell it just because it's so small. But we looked into whether we could divide up this property, and we ran into problems, and that's how this issue kind of came to a head, was the plaintiff filed a complaint saying the trustee had to convey the property in kind, and the trustee disagreed. And so that's where we are.
So unless there's any other questions, thank you.
May it please the court.
Good morning.
Your Honors, since 2007, January 1st, 2007, Ohio has had the trust code. Trust code is a code that was prepared by blue ribbon scholars and attorneys. They work on these codes for a long time. The Uniform Commercial Code was a code early on that was set up. And the idea is to get some continuity among the states in their trust language. And it's also more convenient to learn things if you have a trust code that applies. In the trust code that became effective in Ohio in 2007, it says that a trustee without authorization by the court may exercise powers conferred by the terms of the trust, and except as limited by the terms of the trust, may exercise all of the following powers. So you've got what's in the trust, and you also get the following powers that the law says. The first power, which might be surprising if you haven't been down this road before, is all powers over the trust party that an
What section
unmarried,
of ORC
competent
are you
owner
citing,
has
Attorney
over individually.
Attorney Graff, I'm sorry. What section of ORC are you citing?
That's 5808.15, and it's item 1. And it says that all powers over the trust property that an unmarried, competent owner has over individually owned property. So that's pretty much everything except maybe crimes, something like that. You can do anything right there, anything you want. So you ask, why do people list all that stuff out there? Well, they're just in the habit of that. When the trust code came, it changed. But a lot of people don't know about the trust code. And they also think, gee, it just doesn't look right not to have powers. We've all had powers. You know, trusts go back to the time of the Crusades. And so people are used to looking
So
at
are
those
you saying
powers.
that the authority of the trustee is solely governed by the ORC? Is that
No.
what you're saying?
Well, yeah, no, it's not solely, because I'm going to read the second one. That was the first point that they make. The second was, is any other powers appropriate to achieve the proper investment, management, and distribution of the trust property, and any other powers conferred by chapters 5801 to 5811 of the trust code. So you would have all the powers in the trust, because that's included in everything, okay? It's everything. You've got everything. But that doesn't make sense. So there's item B to this statute, and it says, the exercise of a power is subject to the fiduciary duties prescribed by Chapter 5808 of the Revised Code. So trusts are all about duties. Duties trump powers. So picture the situation of giving the trustee every power they have, but they cannot exercise a power if it breaches a duty. Now, the duties are pretty strict and pretty tough. Section 580801 says, trustee shall administer the
Counsel, I think
trust.
we understand the concepts that you're raising about power and duty. What specific duty are you arguing that the trustee has in this case that would conflict with the powers given to the trustee
I'm
in the
going
trust
to read them now.
documents?
First one is 580801. The trustee shall administer the trust in good faith in accordance with its terms and purposes and the interests of the beneficiaries. These parcels of land absolutely can be divided. It's difficult, but we tried several times. As a matter of fact, we had a drawing that Magistrate Stargell administered, where she created boxes or squares of paper, and she wrote 1 through 14 on these 14 squares.
Even if we agree with you, isn't the issue whether the trustee was mandated to divide the property amongst the beneficiaries as real estate, or whether the trustee had the authority to decide how to distribute that as long as it met the required distribution that was in Section 4?
The trustee never has authority to do something that violates a duty. In this case, this property, there were 14 children born on those properties, all of them born on the same property, to the same mother and the same father. And some of them are very emotionally attached to that property. And their father wanted to make sure that each one of them got a piece of it. They go out there and hang out there and do things and maybe play some games. And so it's important. It's not just something about where they're going to live or something like that.
How do you get around, you do agree that we read the trust as a whole, correct?
Absolutely.
In order to interpret.
Absolutely.
Okay, so how do you get around the other provisions that were pointed out today, and I believe it's Section 5, or Article 5? How do you get around those provisions on distribution of assets and the in-kind division or distribution sections?
Well, that's a power. I mean, it means nothing more than if you put it in or not put it in. They have the power whether it's in the trust or not. Putting in powers in a trust adds nothing to the law because you already have those powers.
But it doesn't say that the division into the 14 shares has to be an in-kind distribution, right?
That's just the English language. They say divide it into shares and distribute it.
Well, then how do you respond to their argument about the tractor?
You have to have common sense, too. I mean, that goes in the law of every statute that you look at. You have common sense. That's never meant to cut a tractor into 14 pieces. It's an absurd discussion.
I understand your argument. As I understood Attorney Prem's argument, Article 4 governed the division, who gets what, upon the death of the grantor. Article 5 governed the powers and duties of the trustee. If I understand your argument, Article 4 governs both the division as to who gets what, but how that, in this case, the real estate is to be delivered to the beneficiaries. Am I understanding your argument?
Yes, certainly what's in the trust is part of what you look at, but you also have to layer on the Ohio law.
Okay, so I want to make sure I understand your argument. So if that's your argument as to how Article 4 is intended to govern, then what do I do with Article 5, particularly the language under section, I believe it's C, disposition of assets? And I'm going to excise the irrelevant parts. Trustee may sell any asset, real or personal. It seems to give the trustee the authority to sell real estate.
Only if it doesn't violate a duty. Duty 580802 says a trustee shall administer
So
the
what I'm
trust.
trying to understand is, what do I do with Article 5, Section C, that seemed to explicitly give the trustee the authority to sell real estate? How do I deal with that conflict that's created by your argument, because you're saying that Article 4 should be read as both who gets the division and how that division is delivered?
When people write trusts, they put in everything but the kitchen sink into a powers clause. They don't know what's going to be owned at the time of death. So they put all these things in. If they apply, maybe they can be used. If they violate a duty, they can't be. You have to apply every power that's listed against the rules of duty. Duty
But isn't the
580802
rules of
says...
duty governed by Article 5?
Pardon? You
Article
don't have
5
to
said-
consider every single thing in a trust because...
If I can finish my question?
Yes.
Okay, Article 5 is entitled Powers and Duties. You say it's not to conflict with the duties. Where else are you reading the duties of the trustee from?
I was trying to read 5808.02, which lists the first duty. 5808.02, A trustee shall administer the trust solely in the interest of the beneficiaries. Solely in the interest of the beneficiaries. Father wanted the property distributed out in 14 shares, and it's in the interest of the beneficiaries to have their father's wishes complied with.
Okay, I understand.
That's where it is.
So what you're saying, because the beneficiaries want it distributed in a specific way, and that language solely in the interest of the beneficiaries, that the trustee has a duty to fulfill the wishes of the beneficiaries. Is that what your argument is?
To the extent that they can be determined, yes, absolutely. I mean, the power,
Well,
Then
counsel,
you have to
would
go
that-
outside the trust document to figure out the wishes of the beneficiaries then.
pardon? Yes, you do have to
To
look
be
at
able
that.
to interpret this the way you want us to interpret it, we have to go outside the trust document. We don't look at the four corners of the trust document, because we don't know what the
You
beneficiaries.
do have to look at the four corners. The four corners says to distribute the property out to each of the children. That's what it says. Now, the notion of...
But it doesn't
of
say
sell-
how.
The notion of well, you distribute it. Now, he says that distribute means to break up. That's not what I think distribute means. Distribute in a will is to give it to somebody. And that's clear. There's no question about what it says.
Can I ask you a question that isn't briefed, and it's okay if you don't have an answer, okay? Because it's not really part of the briefs. I noticed that under 5808.17, Section A, it discusses that upon the termination of the trust, which is what happened here because of the death of the grantor, that the trustee may send to the beneficiaries a proposal for distribution, okay?
Yes?
So it doesn't require the trustee to provide a proposal for distribution, and then it goes on to give a window of opportunity a limited window of opportunity for the beneficiaries to respond to that proposal, okay? So this seems to give an opportunity for the beneficiaries to weigh in on the distribution, but it's not a mandatory obligation to give that notice. So couldn't it be said that that conflicts with your argument?
No.
Okay? If you can explain.
Trustee duties have been in the law for a long time, but they've been codified now since 2007, and people are looking at them much more carefully. People think that if you have a set of powers, and this is trust lawyers all over the place, think that if you have a trust powers, that's what you can do. And if it's not there, you can't. And it's just not true. You can do anything, pretty much anything, as I read earlier. And then you can't violate a duty. That's what it is. Now, you also look at the terms of the trust. And the terms of the trust, in my opinion, make it very clear that he wants his property distributed among the children in 14 shares. I mean, what there says that you can sell it? I mean, the fact that it says you can sell it is a power. Powers are always trumped by duties, if there's a duty. So how can you possibly do justice to the beneficiaries if you're going to sell this property, which means so much to them? Now, not to everyone, but they disagree. There's a group, Ms. Crum and several others, that think you should sell it. But, you know...
But isn't the intent of a trust to effectuate the will of the grantor, not necessarily the will of the beneficiaries? And I understand what you're saying. I can see the emotional attachment. I can definitely see what you're talking about. My family has some land that my grandfather purchased, and my grandfather was a sharecrop farmer. For him to have died with 14 acres in Puerto Rico is pretty incredulous. So I have a brother who has really worked very hard to keep that within the family because he has that emotional attachment. So I understand where you're coming from, okay? But isn't the purpose of the trust to effectuate the will of the grantor?
Absolutely. Absolutely. That's what this is all about. That was the will of the grantor. Clearly, it was the will of the grantor. Let me make one more point. In TD 67, you might want to go back and look at that because this is very, very significant. Mr. Timothy Kutcher was co-counsel with Dave Prem, and he wrote in this document, on the last page, signature is there, he wrote, "It was the testator's intent that the lots be chosen by the trust beneficiaries based on birth order of the children from oldest to youngest." Now, when the draw took place, and everybody drew from the magistrate's container, the draw went more in favor of the younger children. The younger children are Mr. Wynn is one of the younger children.
Where are you citing that from, that representation that you just made?
This is a document that, there's tons of documents that were filed. This is objection to the magistrate's order. It's TD 67, it's in the record. But he says, "It was the testator's intent that the lots be chosen by the trust beneficiaries based on birth order of the children from oldest to youngest." So they were trying to say the older people got to pick first, and then the younger people got to pick, and that's why Magistrate Sargent's draw doesn't work. Well, that's ridiculous. Nothing says about favoring the older ones. The point is, they didn't dispute the fact that this was going to be distributed out. We talked about that for years. This case has been going on for 3 years. We spent tons of time with Magistrate Stargell. Then we started spending tons of time with the probate court.
Well, I believe their argument isn't that it must be sold, it's that it may be sold, right?
It may be sold, according to them, but what I'm saying is that violates duty. You don't have that kind of power. Duties trump powers. I don't care what it says. Every set of powers clauses conflicts with another clause in a set of powers clause. You get everything but the kitchen sink by the lawyers that do it that way because they don't want to be caught without the power. But you still need, if you look at the probate code, at the trust code, you're going to see that you cannot breach a duty. And that's really what it's all about. It isn't about the powers so much, because the powers, whether you say it or...
Just so I understand, though, with the duty, because when you read the language, it doesn't say, it says shall divide into 14 shares. It doesn't say how to divide it. And your argument is it's just common sense that it's an...
No, I'm saying the language itself, if you read it in its entirety of that clause, would say you're going to distribute it out. Absolutely.
But it doesn't say how. The language doesn't tell
says
you
this-
how.
it
It says
says-
shall divide into 14 shares, right? And you're just saying we assume that that means that you keep you just divide the pieces.
Well, I think it says, and you give one share to each.
Right.
Yeah. Yes, that's a matter of reading that would be a matter of reading the English language, I would agree with that, and seeing what that says. Well, I read it, maybe
So
I'm...
that's what our job is, because this is de novo, right? Our review is
Yes.
de novo.
Yes.
So we have to interpret what this means, what shall divide. And you're saying without looking at the rest of the trust.
I look at the whole total of the document, and I look at the words, and I look at what the powers are, and I look at what the duties are, and then you know what to do. That's what you have to do. You have to look at the duties. And the duties are very imposing.
How would we know that this provision in Article 4 imposes a duty and that the language in Article 5, C and P imposes a power? Because Article 5 is entitled Powers, Duties, and Immunities of Trustee. How do we know that Article 5 is a power and not a duty? What tells us that?
Well, the trust code would help, because the trust code talks about the duties. It goes through each duty, and it goes through those duties. And so you would know what a duty is. And then a power is anything. Anything that grants a power is a power. Doesn't make any difference if they're in the trust. So what's in the trust is not really relevant, because it's already there. It's everything.
But maybe I'm not being clear, but why is the language allowing the trustee to sell any asset, real or personal, and then to divide and distribute in money or in kind or both? Why is that a power and not a duty?
Well, it's a power because it's giving them power to do things. And powers are things that you have power to do things. Duties are more about ways that you have to behave to people. You have to be fair. You have to be honest. You have to do this. You have to do that. And it's all listed there. But what you are reading is boilerplate clauses, where they have inconsistent powers, so that you make sure that you have enough powers to cover every asset that you might want to do. And in many cases,
So
attested
I
or
just
wa-
want to make sure that I understand. So the trust document labels this section powers, duties, and immunities. And it's your position that just by reading it, I would be able to ascertain that these provisions are powers and not duties.
Well, not if you read something and it's in the wrong place. I mean, that was done by a lawyer, and he put what he thought was a duty. The duties are spelled out in the code. You can't take them out of the code. It doesn't hurt to put them in places, but they're there anyway. All of the duties.
Okay, so the ORC is the source of duties?
Yes, absolutely.
And not the trust document?
That's correct. I mean, it's not wrong to put them in the trust document, but it's so broad in the duties. You might put a duty that wasn't covered in the trust code and add it there. But I'm just saying, as a practical matter, most lawyers put in everything but the kitchen sink and the powers clause. Most of the time, they don't do anything with duties in trust. But it's fine to.
And so then where in the ORC is the duty to divide this property in kind?
Nowhere. The way it's a duty is you have to look at that language and see that the duty is to be fair with all the beneficiaries. Now, if you really think that it doesn't give that power, then that's a different thing. But to me, it's crystal clear, and it was acknowledged by the other parties when we were doing this draw, and we talked about it. And there were some arguments about who gets what and who gets the first draw. The biggest thing that the trustee thought about was, I want the older people to get the first crack at the draw. I mean, that's violating all sorts of duties, because the trustee has.
Am I summarizing your position correctly? There's a duty to be fair in the ORC, a duty to be fair with the beneficiaries. And it's your position that it would not be fair to the beneficiaries to divide in money and not in kind, given the emotional attachment to the property.
Well, it's the emotional attachment, but it's also the language of the entire document. You've got to look at the entire document and say, what does this guy want to do? And that's easy in some cases and it's difficult in others. This, to me, is an easy case because it's to me, crystal clear that he wanted that property to go outright.
So you're also arguing this is unambiguous?
Well, it's absolutely unambiguous, and so did Judge Winkler say that, and so did Magistrate Stargell said that.
I think everybody's agreeing it's unambiguous, but now everybody has different interpretations of it.
Yes, but the courts, Magistrate Stargell's been around a long time. She had this case for a ton of time, and she knows what she's talking about. She didn't have any question about what it was supposed to be, nor did Judge Winkler. We all know that there's nothing ambiguous about it. It's supposed to go out to the people. Now, the big argument in reality, and you can pick up some of this in the documents because I'm sure that they all got transferred up here as all the stuff went on with the Magistrate Stargell. The big argument was who gets to pick first. That was the big argument. And for a trustee to say the older kids ought to get the first pick is showing right there breach of duty, breach of duty, breach of duty.
Isn't there something implicit in that picking process that suggests that these are not equal tracts?
No, it was going to get divided up. The surveyor was going to drive it up in equal tracts. There weren't 14 tracts. That had to be done by a surveyor to take the three together and combine them and do 14 parcels. And that never got off the ground totally because we never could agree on the manner of making the draw. There was a lot of work that went into trying to figure out how are we going to do this, but that's what he wanted. That's what the testator wanted. And Tom Wynn and his people on his side know absolutely that that's what he wanted. So I think everybody does to me. And they were ready to do that at times, but they couldn't get the first pick. That's what it was. And there are many duties. I think that the thing is that.
So I'll give you 30 seconds to wrap up.
Pardon?
I'll give you 30 seconds to wrap up.
I think the thing to remember is in 5808.15b, it says, after it lists all the powers that you can have, you can just have everything. Everything that an unmarried person can do, you can do as a trustee. But then B says, the exercise of a power is subject to the fiduciary duties prescribed by Chapter 5808 of the Revised Code. This is the most important clause in the law of trusts, period, is that clause. It's not understood by many people, even people who practice in this area, is 5808.15b, the exercise of a power is subject to the fiduciary duties prescribed in 5808. The fiduciary duties are laid out, there are several, number of them, and that's what controls.
Thank you.
So, just like Mr. Graff was confused about making the statement that a lot of people don't know what 5808 means, we're here because I'm confident that this court knows what it means and knows how it applies in interpreting a trust and in the administration of a trust. Mr. Graff is confusing attempts to try to settle this matter with actual duties of the trustee. If the court looks in the record, Magistrate Stargell, who is a great magistrate, and I mean no disrespect to her, made some decisions that we had to object to, and they got reversed by Judge Winkler. So we, in an effort to try to streamline this and try to make everyone happy, we undertook efforts to try to figure out ways to settle this so we wouldn't have to be here today. We settled the issue of the Stanton property. But the issue still remains, not one section, 5808, any place, says if this language is present, you must convey the property in kind. It basically says the trustee has to use a fiduciary duty in the exercise of his or her administration of a trust. Your Honor, I would tell you, Judge Zayas, that 5808.17a was not raised by any party. It wasn't a part of the complaint, and it wasn't an issue in the trial court. And so,
Well, it's
whether-
not mandatory language,
right.
so it wouldn't have been raised unless it was actually, unless the notice had been
If you
provided.
looked at Mr. Graff's complaint that he filed, he cited all these things that he's talked about in his complaint, saying that the trustee had to convey this property in kind. He never once brought up that statute and never once suggested that maybe the court should have this determination. I respectfully disagree with his interpretation about what all the beneficiaries want. The fact of the matter is, if you look at the record, there are at least 4 or 5 beneficiaries that agree that the trustee can sell this property. There are 5 or 6 that don't agree. Well, there's one that doesn't agree, and the other people really never filed or made appearances and filed answers. The court stayed that to try to get through this issue.
But that's really irrelevant, right, to our determination, because we're just interpreting this trust.
But all I would tell you is it's somewhat relevant to understand, what does the trustee do? If these people want this and these people want that, the trustee goes to the trust and says, what can I do? I'll just sell it and give you your money and move on. There's nothing in the trust that says that the people that want to keep it can't buy it. There's nothing that prohibits that, so that might be a possible remedy. The sole issue here is whether 580801 at SEEK prevents the trustee says, as a matter of law, that this property cannot be distributed in kind, in money, partly in kind or partly in money. It does not, and so we're asking you to reverse the decision of the probate court. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. And we wish you both and the family a wonderful afternoon and a great week. Thank you. And that concludes our hearings for this morning. Thank you.
The Court of Appeals, First Appellate District of Ohio is now adjourned.